Hi everyone and welcome to today's webinar on diverse sexuality, gender identity and discrimination law in Queensland. This is a webinar run by ADCQ, which is the Anti-Discrimination Commission Queensland, and Legal Aid Queensland. I'd just like to let you know that the webinar is for community legal education purposes only. It will be recorded today and published on our YouTube channel, Legal Aid's YouTube channel. Okay, and I should introduce myself. My name is Catherine Bowden and I'm the Community Legal Education Officer here at Legal Aid. I'm just going to start by going over a few housekeeping slides today. So as I said, it will be recorded and published on our Information for Community Workers and Carers page on Legal Aid Queensland's website. Now I just want to check that the technology is working for everyone, that you can see us and hear us. If you don't mind raising your hand quickly and I'll make sure everything's working. Thank you. I can see those hands raising now, so go ahead and pop that back down. If you are having any technical help, the phone number's on the screen now, so please call 1-800-136-402 and that's GoToWebinar's helpline. Okay, now you should all see something on your screen that looks similar to this. You should be listening in using your computer speaker system by default, and you have been muted for the purposes of today's webinar. So when it comes time for questions, we'll let you know how to type those into the questions box. And just a reminder to only ask general and useful questions, please. Don't use clients' names, don't ask specific questions about your clients. You'd be more better to often rephrasing those so that it can be useful for everyone in the webinar today. And if you'd like to download the slides for today, please go ahead and click on the handout section now and you can download that PDF. Okay, now we're going to run a quick poll. So we're interested to know about what area you work in Queensland, or whether you're from outside of Queensland. Do you work in Southeast Queensland, which it looks like most of you do, or Far North Queensland, regional, or outside of Queensland? So far everyone's from within Queensland, which is great. I've got 5% from outside of Queensland. Okay, I'll go ahead and stop that there and I'll share the results with you if you're interested in seeing. 70% of you are from Southeast Queensland and we've got 17 from regional, a few from Far North and outside of Queensland as well. Okay, we're going to run a few polls this morning, so could you please tell us how you would rate your knowledge of Legal Aid Queensland? You've got a high knowledge of legal aid, do you feel like you know a lot about us or a good amount about us and you're still ready to learn more? Do you have a limited knowledge and hopefully you'll learn a lot today? A lot of you have good to limited, so yeah, hopefully we'll be able to teach you a lot more about legal aid and also about ADCQ today as well. Okay, I'll go ahead and close that there and share those results with you, so you can see most have a good to limited knowledge. And final question before I hand over to our presenters. We're just wondering who your clients typically are, whether you work mostly with young people, mostly with people with a disability, or from culturally and linguistically diverse backgrounds, or if you mainly work with Aboriginal and Torres Strait Islander people, or just the general community. I've got a lot of you who work with the general community. It's a hard question to pinpoint that, I know. Just got a few more people putting their answers in. Okay, I'll go ahead and share that with you again. So we've got 72% of you, your audience is general community, which is to be expected, and we've got a few of you in specialist areas who are looking at young people and also people with a disability and Aboriginal and Torres Strait Islander people as well. Okay, just so you know, for those of you who are from outside of Queensland, today's webinar does relate to the Queensland jurisdiction, so it may not be applicable to you in your states. You're very welcome to still sit in and listen along, but we just advise you to check the law in your own state. Okay, and before I hand over to our presenters, I just want to acknowledge the traditional owners of the land on which we meet today and pay our respects to elders past, present and emerging. And so today we've got Heather Corkill, she's the manager at the Anti-Discrimination Commission Queensland, and then on the end here we've got Matilda Alexander, and she's a senior lawyer in the Human Rights and Anti-Discrimination team at Legal Aid Queensland. So I'll pass you over to Heather to start with.
Actually to Matilda.
Yeah, to Matilda.
I'd also like to acknowledge the traditional owners before I start and to pay my particular respect to the members of the LGBTI community in the Aboriginal and Torres Strait Islander community, so groups like Bundjalung and DigiLes and Two Spirits. So today's presentation is going to be introducing the concepts of direct and indirect discrimination, vilification and sexual harassment. And we're going to look at how these concepts relate specifically to people who identify as lesbian, gay, bisexual, transgender, intersex and other sexualities, and gender diverse people and communities. We're going to provide some practical tips for caseworkers if your client is experiencing discrimination. And we're going to explain how to get help and access resources from the Anti-Discrimination Commission of Queensland and from Legal Aid Queensland. So many of the examples and case studies that we're going to refer to are real life examples and scenarios. So some of them contain offensive language, including homophobic and transphobic words and behaviours.
So I'll jump in here. I did want to quickly introduce some new resources that the Anti-Discrimination Commission has put together, and they're actually specific resources for the LGBTI community, or perhaps for people who are employers of people who are LGBTI or their colleagues and peers. And so I just wanted to take you through on the Anti-Discrimination Commission website where you would find this. So if you can just follow the rainbow, it's pretty easy to find. So if you'll see it on the landing page here, so lesbian, gay, bisexual, transgender, and intersex people, or you can go up to the resources link and find it here. So if we click through, you'll find that there's quite a lot of useful resources that splits up between sexuality and your rights, gender identity and your rights, some general information about human rights protection for LGBTI people, some frequently asked questions that the Commission gets that hopefully will be helpful, and we may be able to go through some of those today. Some specific resources for the community, terminology if you're wanting to know what a particular term means, you're not familiar, and just a few referrals as well. So we might periodically come back to some of the examples from the website, and you're welcome to have a look at that in your own time as well. Now before we move through the slides again, we're going to do another poll. So the poll will be, unlawful discrimination can happen. Do you think it can happen at a primary or high school, in your local cafe, in a dentist waiting room, when applying for membership at the local RSL club, or all of the above? Just let us know what you think is the right answer there.
And Heather, it's looking like a lot of people are believing this would be the case with all of the above.
Yeah, it looks like it. So I think we're pretty much unanimous in that one. So that's exactly right. So what we'll talk through firstly, and I'll just move on to the next slide, is I'll be talking to you about the requirements for fitting under the Anti-Discrimination Act, and one is that you attribute under the Anti-Discrimination Act, and the other is that there needs to be an area. So we'll go back to talk about the area issue in a minute. But there's actually 16 attributes that the Anti-Discrimination Act covers. Now the ones that I've actually highlighted there are the most relevant for today's purposes. So sexuality, gender identity, and association with a person who has one of those attributes. So association with might be, let's just say you're a parent of a child who's trans, for example, and you're discriminated against because your child is trans. That's what an association would mean. Sexuality is a very simple definition. It's what you'd expect. So it's just whether you're heterosexual, gay, lesbian, or bisexual. And gender identity has a specific meaning as well, and that's whether you identify as a member of the opposite sex by living or seeking to live as a member of that sex. It does include people as well who are intersex. as a general term of gender identity. And I acknowledge that those are two very different things, but for the purpose of the legislation, we'll be referring to gender identity for people who are both trans and intersex. So just on to the next slide. As I said, the discrimination is the only coverage under the Anti-Discrimination Act is where it falls in an area of activity under the Act. Now, those are generally areas of public life, as opposed to private interactions. And so the sort of things that where there's coverage is obviously at work. That is by far our most common area when we receive complaints. So at work or just applying for work, so pre-work processes. At school, TAFE, university, if you're going to any sort of accessing any goods and services like a shop, hotel, restaurant, doctor, dentist would all be covered. Also accessing superannuation or insurance is covered. Also getting accommodation or seeking accommodation, so whether that be renting or going to a hotel or whatever. And also club membership and affairs is covered if so long as it's a for-profit club. And also using government and local council services. So anything that's a state government provision of service or maybe something provided by a local council is all covered by the Anti-Discrimination Act. So you may note that there are a couple of things that are included. So for example, things that happen between neighbours may not be included. Sometimes, like if there's a person in, say, goods and services who's actually providing a service, so they're, maybe they're a dentist and they're providing a service to a client who says something homophobic to them, that dentist wouldn't actually be covered because the goods and services is only from the person who's receiving a service. So that's and there's a couple of examples where it doesn't apply, but you'll see across the board it usually applies to most areas of public life. So I'll lead in now to a few examples to give you furnish a few examples so you have a bit of a better idea about how this actually applies in practice. So if the first example is a goods and services one, so if a specialist refused medical care to a woman because she's a lesbian, then that would be discrimination because of her attribute, and it's in the area of services. So basically, direct discrimination is unfavourable treatment because of the person's sexuality or gender identity, and that's compared with others in the same or similar circumstances. So you're sort of looking at, is it because of their attribute that that's actually occurred, and is there an area of activity? So the second one, a real estate agent choosing not to rent a property to a same-sex couple, even though they're otherwise the best applicants. So compared to a heterosexual couple, they, or maybe a single heterosexual person, they are being disadvantaged. So they're being treated less favourably because of their sexuality, so would be covered by the Act, and that's in the area of accommodation. The final example is a gay man being refused membership of a gym on the basis of his sexuality, so that would be membership of a club or maybe goods and services as well. And if it's because he's a gay man as opposed to a heterosexual man, then absolutely would be covered by the Anti-Discrimination Act as well. So I do have a couple of, those were examples in relation to sexuality. I've got a few that I'd like to provide in relation to gender identity as well. So if this is another goods and services example, so if a beauty therapist refused to treat a woman because she's trans, so if they, for example, say, oh, I only treat someone who they recognise as a woman, but this person identifies as a woman, then this would be sort of less favourable treatment because the woman is trans. Again, if a trans woman is refused entry to a women's only gym, so not recognising that she identifies as a woman and therefore is protected by gender identity, again, it would be discrimination in goods and services. I've got a couple of intersex examples as well. So if there's, say, really unfavourable comments said to a person in a workplace, such as freak or hermaphrodite, is said about a person, that's linked clearly to their being intersex and it's happened in an area of work, again, would be covered by the Anti-Discrimination Act. And the final example is a barber refusing to provide a haircut to an intersex person because in their mind they'll only serve a male customer. Now that person doesn't fit neatly into that category of what that person sees as a male, and therefore that would be discrimination on the basis of gender identity again. So hopefully that gives you a good range of examples, but look, if there's other questions you've got towards the end, you're welcome to put anything else up to us so we can answer. But for now, I'll just hand over to Matilda to describe indirect discrimination, which is a much more difficult beast to tackle, to say.
It's much harder to spot because it's usually in a situation which appears neutral or the same for everyone, but in fact discriminates against people with a particular sexuality or gender identity. It can be unlawful indirect discrimination if a person or organisation imposes or proposes to impose these 4 things. The first one is a term or conditional requirement. This includes things like a policy, a rule or a practice, whether or not it's written, which appears fair as it applies to everyone equally, but a closer look shows that certain people with certain attributes are actually disadvantaged. So the second thing that's required is that the person with the attribute cannot comply with the term or condition due to their attribute. So the person alleging indirect discrimination doesn't necessarily have to show that they physically can't comply with the term, only that they can't comply in a practical sense, that they can't comply with dignity with that term. So the third thing is that a higher proportion of people without the attribute can actually comply with that term or condition. And for looking at that, you just consider some statistics can assist with evaluating that. And the final part of the test is that the term is not reasonable. So when considering whether or not a term, policy or practice is reasonable, you can consider things like the consequences of the failure to comply with the term, the cost of alternative terms, the financial circumstances of the person who proposes to impose the term. And an interesting thing is that it's actually not necessary to do this maliciously or even intentionally. So the person imposing the term or making up this rule might just never have thought of your circumstance, and that can still be unlawful. It doesn't matter if they didn't mean to discriminate against you. So some examples of indirect discrimination would be in relation to a transgender person. So an employer telling a trans woman that she must use the male toilets at work, and vice versa, an employer telling a trans man that he must use the female toilets at work. And that's not just at work, it might be, say, within an educational context as well. So telling a trans student that they must use the toilet they don't identify with. Or a rule that a year 12 student must take an opposite sex partner to the formal. Again, it's something that seems neutral. You have to take someone of the opposite sex as your partner, but when you look down at it, it actually discriminates against people who it's harder for somebody who's same sex to comply with that. They cannot comply with it in a realistic sense. So a workplace, another example is a workplace where homophobic jokes are regularly made in the lunchroom. So for somebody who is gay or lesbian or transgender, intersex, coming to work every day in an environment of homophobic jokes is a term that they are much less likely to be able to comply with who is heterosexual. So all of those are examples of indirect discrimination. So we've been talking about discrimination. The Anti-Discrimination Act of Queensland and the federal equivalent as well provide for protections against discrimination, but they also provide for protections against sexual harassment and vilification. So we're going to move on now to talk about sexual harassment. So sexual harassment is unlawful. It's unlawful to behave in a way that is unwelcome and sexual towards a person where it may offend, humiliate or intimidate that person. It happens when a reasonable person would expect that you'd feel offended, humiliated or intimidated by the conduct. It's got nothing to do with mutual attraction or friendship between the people. So, for example, sexual harassment can happen between a man to a man, regardless of whether or not he identifies as homosexual or gay. So, or it can happen between a man and a woman. It can happen between a trans person and a non-trans person. So it's not to do with your sexuality. It's to do with the behaviour that's happening. So when applying what is reasonable, you take into account all of the relevant circumstances of the situation. So it might be the sex, the age, the race of the other person, whether the other person has an impairment, and the relationship between them. So relationship could include the relationship of an employer to an employee, or if you previously had a relationship, a consensual relationship. Yeah, so it doesn't just include physical contact, although it certainly does. It includes physical contact, but not only physical contact. It also includes comments of a sexual nature. So examples of sexual harassment are things like, you know, lewd, sleazy comments, smutty jokes, brushing against somebody, asking for sex, emails, or repeated requests for dates, especially after a prior refusal. Some conduct may also be sex discrimination or sexuality discrimination. So these things are all sexual harassment and can be unlawful anywhere or any time. So sexual harassment is a bit different to discrimination, because discrimination needs to happen within one of those areas we were talking about before, with you know, needs to happen in a school or in the provision of government services or in delivering goods and services. Sexual harassment can happen anywhere, anytime. It is unlawful. So I'll hand over to Heather to talk about another aspect that is covered by the Anti-Discrimination Act of vilification.
Okay, great. So vilification is unlawful in Queensland, and that's where there's actually a public act towards a person or a group of people that could incite hatred, contempt or ridicule because of that person or their group, because of their race, religion, sexuality or gender identity. So for the purposes of today's discussion, we'll focus in on sexuality or gender identity. So as you can see from that, that's actually four aspects to vilification. So of course it has to happen in public. So you know, whether it happens like at a local shop, or let's say it happens over the air on the radio, or you know, there's perhaps in a maybe sometimes in a neighbourhood scenario, as long as it's capable of being heard and is at a certain volume that members of the public walking past could hear. Those are some of the examples of what public would actually mean. So it's not things that are said to someone in a private setting. So the act must incite hatred, serious contempt or severe ridicule towards a person or a group of people. So it could be a comment because that person is a lesbian, for example, or it could be a comment against all people who are lesbian. And so there's got to be that link, of course, to the gender identity or sexuality. And it's also worth noting as well is that there are also provision under the Act for serious acts of vilification. So serious vilification takes it up to a notch where there's actually threats of harm or to people or property. Now those can actually be prosecuted as a criminal offence as well. So complaints of vilification can actually be made by an individual, or they could actually be made by a group of people, or that actually look after the welfare of a particular group. So if there's like an LGBTI community group that wants to take up an action of vilification, then that's actually an option as well. And you know, and sometimes I think that that's actually a more appropriate way of dealing with vilification rather than placing that onus on an individual. So. We're going to do a bit of a poll about vilification now, so we'll test if you've been listening to me. So the question will be, what three things do you need? So words inciting hatred, serious contempt or ridicule, located at a workplace or accommodation, or about someone's race, religion, sexuality or gender identity. Which three of those must it be?
We might give you a bit of extra time to answer this question. I can see half of you have voted.
Yeah. I think everyone's pretty spot on. So it needs to be it needs to be A, B and C. So it doesn't actually need to be
A, B and D.
A, B and D. My apologies, A, B and D. So C mentions it's got to be a workplace, school, shop or accommodation. Now that kind of hints that there's got to be an area of activity. And for vilification, again, it doesn't need to be under a specific area of activity. It needs to be a public act, but it doesn't need to be a scenario where it's capable of being heard by members of the public. So that's quite right, that it doesn't have to be at a workplace, school, shop or accommodation necessarily. And now on to a couple of vilification examples for you. So one we've got is a radio host using highly offensive homophobic language, laughing at and belittling gay and bisexual men on the air. The reason why that's vilification is because it's public. Of course, it's broadcast. You know, there's nothing more public than that. And the words are highly offensive and belittling, so I see that as potential contempt. And also belittling indicates it's probably ridicule, and it is directly linked to gay and bisexual men, so that link there is there to the sexuality. Another example is posters. So there has been some case law on posters. It's like that's clearly a public act, so posting a poster that people from the public can see. And if the poster says that lesbian mothers are damaging their children because they're exposed to their mother's sexuality, that's clearly quite serious contempt of lesbians as a group. So would meet the threshold, I think, for incitement of hatred or contempt, and again a public act, and again certainly linked to that group of people's sexuality. And the final example we've got is a little bit different, and that's where it's a neighbourhood scenario. So if a neighbour of a trans woman is yelling out constantly from a unit complex that they intend to bash the she-male living next door, then we would meet all the elements of vilification. Again, a public act, the fact that it's actually capable of being heard by the other people that live in the complex, or maybe people that passes by on the street, means it's public. It's certainly that the words are, I think, obvious and offensive, so would be meet the threshold for incitement of hatred, and also it's directly linked, she-male is a highly offensive comment that's directly linked to people who are gender diverse. So I think it meets all those components of vilification. So I'll hand back over to Matilda to start going through a few examples that we've given of some case law.
Yeah, so these are actual cases that have gone through to tribunals and had decisions made in the Queensland context. So the first one was discrimination in a workplace, and Mr. Kelly was employed at a caravan park. His boss, Mr. Moore, made comments about his sexuality, including calling him a shirt lifter on 2 occasions. He also asked him, how could you have sex with another man? Other work colleagues as well made unwelcome comments about Mr. Kelly's sexuality. Now, the Anti-Discrimination Tribunal found that calling Mr. Kelly a shirt lifter constituted direct discrimination. So somebody who didn't have that sexuality would not have had to put up with those terms. The company employing Mr. Moore, the caravan park, was vicariously liable for those comments. So sometimes an individual can be responsible, and if they're employed somewhere, that means their employer is also responsible for the actions of the employee, and that's called vicarious liability. So in that case, the tribunal awarded $2,000 to Mr. Kelly for compensation for the discrimination that he'd suffered. So another example is discrimination in the area of goods and services. And this is a case where a transgender woman was walking down the street in front of a grocery store and a bottle shop. The bottle shop employee called out "drag queen," and the grocery store employee laughed. The transgender woman later went into the bottle shop and attempted to talk to him about the incident. She then went into the grocery store and attempted to buy goods while also talking about the incident. She was refused service by the grocery store employee. And here the Anti-Discrimination Tribunal commented that the transgender woman had been treated differently to other women because she had wrongly been presumed to be a man and a transvestite. So in that case, she was awarded $9,000 compensation. The next example we have is so those were examples of discrimination. So now we're looking at something that was constituted both vilification and sexual harassment. And sometimes you'll find this where one particular incident could offend multiple parts of the Anti-Discrimination Act. In fact, one incident could be discrimination, vilification, and sexual harassment, depending on the context. So here, this was in the context of public acts by neighbours, and the complaint was vilification and sexual harassment relating to an ongoing dispute between a same-sex couple and their mother and son neighbours. The Anti-Discrimination Tribunal found that some of the incidents that they were describing amounted to vilification under the Anti-Discrimination Act because they were public acts, they were designed to incite hatred towards, contempt for, or ridicule of the complainants on the grounds of their homosexuality. So some of the things that were said, they were called faggots to their faces, to the landlord, and circumstances where the neighbours were potentially able to hear it. And when Mr. Wilson, one of the same-sex couple, was in his driveway getting help from a mobile battery supplier, the neighbour peered over the fence and said, "Make sure those puffs pay you. They have a habit of not doing that." So they were the things that were found to be vilification. And the tribunal also found that some of the remarks amounted to sexual harassment because they were made with sexual connotations and with the intent of offending, humiliating, or intimidating them. So you can see here an example of how sexual harassment is completely unrelated to, say, a mutual attraction. So, for example, Mrs. Lawson repeatedly described the complainants as faggots, and her son referred to the same-sex couple next door, Mr. Wilson and Mr. McCollum, repeatedly as princess, with a wolf whistle, as ladies, as girls, and as puffs. So they said in that case, those comments were sexual harassment. Interestingly, they said that the use of the term wanker was not sexual harassment because it didn't contain a sexual connotation. So in that case, there was compensation awarded of $9,500 and $11,500 to the two complainants who brought the complaint for sexuality, vilification, and for sexual harassment. So Heather mentioned as well that there's another level of vilification. There's vilification as a offence, and then there's as a contravention of the Anti-Discrimination Act, but then there's serious vilification, which can also be a criminal offence. So this is an example of serious vilification on the basis of gender identity. So in this case, a transgender woman was successful in proving a complaint of gender identity vilification at a hearing before the Federal Civil Administrative Tribunal. Now, the reason why some of these cases refer to the Anti-Discrimination Tribunal and others refer to the Civil and Administrative Tribunal, it's just that there was a change in jurisdiction. The tribunal got a new name. And more recently, there's been a further change where some of these matters will be before the Industrial Relations Commission, where they're employment related. But they're all relating to the same law. They're all the same, applying the same legal tests. The complainant, so in this one, the complaint related to an incident which happened late at night when the woman was at home. She was awoken by yelling from the footpath outside her home. The stream of abuse and obscenities related to her gender identity followed. One of the group then pulled a wooden paling from the woman's fence and called out to the others, "So has anyone got a box of matches so we can burn this fucking faggot's place down?" The respondent did not appear at the conciliation, in the commission, or at the tribunal hearing. And the member, which is a way of saying the judge, I guess, found this form of gang-style violence constituted sexual harassment, vilification on the grounds of gender identity, and also serious gender identity vilification. So where a person or their property is threatened with physical harm, and this can also be a criminal offence. So the member didn't order, so one of the things that can happen after these kind of cases is an apology, and here the member decided not to make an order for an apology because she felt that the non-attendance at the proceedings suggested that he wouldn't take it seriously, and a private apology. So an award of $15,000 in compensation was made, and $10,000 was awarded for the vilification and $5,000 for the sexual harassment. So again, you can see the same Act has offended multiple parts of the Anti-Discrimination Act. And I'll hand it back over to Heather to describe the Anti-Discrimination Commission.
Okay, thanks, Matilda. So the Anti-Discrimination Commission does have a number of purposes. I'll be focusing here on our sort of complaint management role, and I'm the manager of the Brisbane complaints. So what we do is we receive complaints about any of the breach of the Anti-Discrimination Act. And then what we do is really try to help people resolve their conflicts and try to basically move on with their lives through a conciliation service, which is a little bit like going through a mediation. The difference between a mediation and conciliation is simply that we are informed by the Anti-Discrimination Act, and we will actually talk you through where we feel it fits under the Act. But other than that, it's really there to provide a service to not just complainants but respondents as well, to see if we can move forward together and try to reach a resolution on the matter before it has to go before a tribunal or commission, as Matilda was mentioning before. These matters can continue through to QCAT or the QIRC for an order to be made. But the idea of conciliation is try to get an early resolution to save everyone the time, stress, and I guess that there's a lot of costs involved as well with moving forward. So we try to mitigate all of that by resolving matters. We also do have other parts to the Commission. So we have education and training programs as well. And that's where we're basically trying to prevent discrimination before it occurs. So just trying to explain to people what their rights and responsibilities are under the Anti-Discrimination Act. So the Anti-Discrimination Commission's complaint process, the key thing to be aware of is that there is actually a 12-month time limit to lodging complaints, which can be extended only if there's good cause to do so. So it's important to advise clients that there is that time frame running so that they are prompt in lodging complaints. Now, the first stage is we do actually assess whether the matter does potentially fall under the Anti-Discrimination Act. And that's not actually a matter of weighing up the evidence or making a decision on the merits. It's just simply, does it fit under the Anti-Discrimination Act? So we're looking for the obvious things like, is it under an area? Is there an attribute that it seems to be based on? Is there some unfavourable treatment or some sort of indirect discrimination that's occurred? So it's a fairly low threshold. As beneficial legislation, we're really trying to help everyone we can. But there is the process of just identifying whether the person's in the right place, because there's no benefit in staying in the wrong jurisdiction, we feel. So once we've accepted the complaint, we then notify the respondents to that complaint. They are given the opportunity to provide a written response if they wish to, but we immediately set the matter down for a conciliation conference. We then run a conciliation conference within 28 to 42 days after we've accepted the complaint. And then at the conference, we usually runs for up to 3 hours, mostly face-to-face, some by phone. Of course, for people who are in regional and remote areas, we sometimes need to use the phone, or for other reasons, people might prefer the phone, and we're always open to that. And so after the conciliation conference, sometimes the parties can get to an agreement on that day. Other times we can try to resolve it through a post-conference negotiation. Once everyone's agreed on something, we can actually register that agreement with the tribunal or the commission to make that a binding agreement on all parties. Now, if there's no settlement reached through conciliation, the parties, the complainant does have the right of referral, and they can choose to take that through to a public hearing. And they have to make that decision within 28 days of the conciliation conference, when the matter is considered to be unconciliable. So if that goes through to a public hearing, then a tribunal member would actually make a decision as to whether there has been discrimination or vilification or sexual harassment or whatever the breach is, and then make an order, which is almost always around kind of compensation. Very occasionally it might be about public apologies, but mostly it comes kind of down to money. Whereas I would say in conciliation, the benefit of that is we really encourage people to come up with creative outcomes to try and resolve it, and we have all sorts of sort of systemic outcomes we come up with. So, for example, that the respondents might agree to undertake anti-discrimination training, or there might be a review of the internal complaints process to try and so that if someone else goes through something similar, that it could have been resolved internally. Those are the sort of things that we might be able to come up with through conciliation. So just a little bit about who complains. So I think at the moment we're getting around about 600 or so complaints a year. So this is data from about 2014-15, so it's not completely up to date, but it's fairly accurate, I'd say. So that was about 60 people that year. So I'd say about 10% of matters were sexuality matters. And of those, probably most of those people who put in inquiries did actually make a formal complaint. Next slide, thanks. And here's the sort of breakdown of when people did actually complain about sexuality or gender identity. What were they complaining about? So as you can see, a lot of the largest proportion is discrimination on the basis of sexuality, and discrimination on the basis of gender identity was the second most popular in terms of a complaint, and then vilification, gender identity and sexuality were less common complaints, and then some complaints based on unnecessary questions because someone's sexuality or gender identity were a very small proportion of the complaints received. Now, of those, it's actually a very high proportion of those complaints are actually conciliated. Usually, I would say about 55 to 60% of our matters overall are conciliated, as opposed to sent on to a tribunal or commissioned for a hearing. But in the case of these particular 60 matters we're looking at here, we had a very high conciliation rate of almost 90%. And sort of a fewer numbers were, we did have quite a lot that were not under the Act. So as we were saying before, we do have the sort of filtering at the start of the process to identify whether it is actually something we can manage or not. Yep, so we'll move on. And I do actually have an example of a conciliation. And so I thought I'd talk you through the scenario and I guess a bit about the conciliation process to give you a bit of insight into what might take place if one of your clients was to lodge a complaint and go through conciliation. So it was about a situation where a complainant had suffered discrimination in a sort of a male-dominated industry when his co-workers learnt he was homosexual. So he was subject to taunts, he was slapped on the head, hit on the backside, and excluded at lunchtime. So quite serious behaviours towards him. When the discrimination was reported, there were delays in dealing with it as well. So it wasn't one where, in fact, the company had done very well at trying to internally resolve the matter. And that's something we often see when things aren't dealt with early on. They can often sort of snowball and become, you know, the emotions are quite high by the time people come to conciliation. So the impact on the complainant was severe. So he'd gone on stress leave and he'd suffered agoraphobia because he also feared victimisation as a result of his complaint. So he was fearful of the fact that he'd lodged this complaint and what might happen in the workplace. So in this matter, the complainant was not keen to meet with the individual people face to face and was feeling emotional about that process, and also that his solicitor would only be available by phone. So we did facilitate a phone conference based on all parties' needs. And we arranged also for a support person to actually raise the complainant's faith in the process and his trust that he would be given a sort of fair hearing, so a fair go in the process, I suppose. So we would have had all parties attending by phone, with the complainant having the access to his solicitor, but also a support person, which is a non-speaking role, with him there in person as well. Now, all of but one of the respondents did deny the allegations, but I will say that in almost all matters that I've conciliated, there is a dispute of facts. Now, that doesn't mean that there can't be a settlement of the matter, and it's very common that we don't have any, sometimes no agreement on the facts. In this matter, there was some agreement only on what had been said or done towards him. However, the conciliation did take a positive turn because the lawyers did start negotiating towards some sort of resolution. And we, at that point, would have been in some private sessions with the parties. So we do have an exploration of the issues in a joint session, but all the negotiations people find a lot more comfortable to sort of go through in private sessions. So that's the time where we as conciliators can talk through where the matter might fall under the Anti-Discrimination Act, and also start talking about what might actually resolve the matter. So in private, the respondents did express a willingness to apologise to the complainant for causing him any distress by their behaviour and to allay his fears of retribution if he saw them in public. So the conciliator brought the parties back together, and there were apologies and handshakes that were genuine and contributed to a positive experience for both the complainant and respondents. And then there was an agreement as well for the financial side of things, which was to provide a statement of service and also to acknowledge the pain and suffering. The complainant was paid $17,500, which was made up of both compensation for hurt and humiliation and also lost wages. If there's any, this is some contact with the Anti-Discrimination Commission. So if you are not sure if this is something that applies to your client scenario or you'd like to get some information, then feel free to give our inquiries line a call, which is on the screen now. And I'll just hand over to Matilda to talk about the LAQ contacts.
Okay, so we've got quite a few different offices around Queensland. You can see them all found here. Not all of those offices practice in discrimination law, but they will all be able to put you in contact with someone who does within the organisation. And here's the contact details of how to call us.
Okay, thank you. We might open up for question time now, but I'd just like to thank Matilda and Heather for presenting to all of us today. It's been very insightful for me and I'm sure for our audience as well. And we did have a couple of questions that came through beforehand which we can get started with. Now's a good time if you've got those burning questions to type them into the questions toolbar, which you can see on your right hand side. And Matilda, I might just ask you to pass me that question sheet next to you there, because we jotted down a few insightful ones earlier that we'd like to share with you guys. Thank you. That's great. Okay, so this might be a good one for you, Heather. What toilets can trans persons use?
I might just borrow that back, thank you. Well, a trans person can use the toilet that reflects their affirmed gender. So in other words, the gender that they are living as or seeking to live as. So a trans person may prefer to use a unisex toilet or accessible toilet, but should never be required to only use a unisex or accessible toilet, because that's actually still differential treatment from someone else. So telling a person that they must use a toilet that does not reflect their gender identity may actually be discrimination. So that's within, I think, as Matilda mentioned before, that applies often to workplaces, but it could apply to schools and other scenarios, such as like accessing toilets at a pub. We've had a complaint around that recently, so something to be well aware of.
Thank you. The next question we have on there is around what it would take for a trans person to be recognised under the Anti-Discrimination Act. Do they need to take actions such as hormones or hormone tablets or changing their name and things like that?
Well, so I might address that. And yeah, sometimes people think, do I need to change my ID? Do I need to have surgery? The Act actually defines gender identity discrimination as relating to a person that identifies or has identified as a member of the opposite sex by living or seeking to live as a member of that sex. So it's not about your biology or physiology or how many surgeries you've had or what documents you've changed. It's about your genuine identity in the world. So, and there has actually been a High Court case of AB and AH against the state of Western Australia, and that one went all the way to the High Court that confirmed you can't just look at someone's so-called biological characteristics, or you can't just have something simplistic like considering their genitals or what surgeries that they had. You actually need to look at how is that person identifying and being recognised in the world. And yeah, so for somebody, if somebody who is identifying as transgender and presenting that way, then that gives them enough to be covered by the Anti-Discrimination Act. So any discrimination against that person on the basis of their gender identity is unlawful.
Thanks for that, Matilda. We've had a question come through, which is just going back to what actions are taken when businesses or individuals have committed an offence. Are there any actions that are taken other than just making an apology or paying the fine?
I could probably take this one in relation to, if we're talking about the conciliation example, the process is not a punitive one. So it's not there to punish the complainant or respondent. As impartial parties, we don't actually take sides and say, you know, wave the finger and say you've done the wrong thing. It's actually more about a restorative process for the complainant. So it's more about taking them back to the position they would have been if it hadn't actually been for the acts of discrimination or sexual harassment or whatever against them. So there is, I guess, in relation to, I guess, more like the case law, if that's what we're talking about, then there's probably, I guess, in a way, being in the public realm is punishment in a way. The fact that there is impact on the business reputation is something. Is that I think probably businesses do not take lightly at all. But other than the award of compensation, there's not any other sort of criminal punishment of any kind that takes place. So
yeah, and there's actually the powers under the Anti-Discrimination Act are quite broad in terms of what the tribunal can order. It says they can order things like a private or a public apology, or require implementing programs to eliminate discrimination, or to pay compensation, or to do specified things, or just not to commit a further contravention of the Act. So they're not limited to just those things. The tribunal and some of the outcomes that we've seen through conciliation are actually quite creative in terms of what's going to be the best fit for that particular factual scenario.
Thanks for that, Matilda and Heather. We've had a question around school uniforms. So if a child identifies as a female, does the school have to comply with any kind of legislation and allow the child to wear the female uniforms? Are there any rules set in place to make the schools take these actions?
Might leave that one to you, Matilda.
Yeah, so for, I guess, it's in relation, I assume this question's in relation to a transgender student who's identifying as a female. Yeah. Yes, the school is required under anti-discrimination laws. The laws apply equally regardless of age. So a child can actually bring a complaint either together with a support person or by themselves if the school does not allow them to wear the school uniform of their choosing. So that could be, I guess, direct or indirect, because a girl who doesn't identify as trans is able to wear the uniform.
Yeah.
So that's the clear discrimination there. So she should be treated not just in relation to uniforms, but in relation to school excursions, bathrooms, a whole range of different things. She should be treated like the other girls.
Thank you. I'm just reading through a couple more questions here, but we did actually have one before the webinar around disability. We had a few questions. Are you guys able to talk about disability during these situations?
Yeah, I think the sort of question we had was fairly general. It was around, do people with a disability have the right to freedom of expression of their sexuality? And I would say yes. So I'd say, just in a general sense, that the Anti-Discrimination Act in relation to sexuality and gender identity equally applies to people with impairments or without impairment. So certainly I'd probably need to hear of something more specific in terms of questions to be able to answer anything in a more specific way. But yeah, certainly if there's sort of no difference in terms of the rights of a person, whether they've got some disability or not. Yeah.
Thank you for that. So our next question is around when people are working in a cafe or a restaurant or a fast food outlet. Some workplaces will say the females need to be on the front counter while the males are out the back cooking burgers or whatever it might be. What would you do in a situation where a female actually would prefer to be out the back cooking, or a male would prefer to be on front counter? How would you get around that kind of discrimination there?
That's probably more likely to be sex discrimination rather than sexuality discrimination, although for a transgender person they should be treated the same way as the other people of their gender identity. But yeah, certainly unless there is a genuine occupational reason why the workplace needs to be divided along those gender lines, it would probably be sex discrimination.
Okay, thank you. I believe the question here was where a female did identify as a male, but they were still being made to serve on the front counter.
Yeah, well, I guess in that case, he should have the option of being placed with the other men.
Okay, thank you. Okay, I'm just working through a few more questions here. So, what happens if someone is transgender and they're seeking crisis accommodation? However, sorry, just trying to understand this question here, which is only funded to fixed categories of gender. So they're seeking crisis accommodation. They might identify as male, but they are transgender, and then they would try to be pushed in with other females instead. What could they do? What steps could they take?
So I guess the thing is, if they are a trans woman, they should be treated the same as other women and should have access to women's crisis accommodation. It can be a little bit tricky with a trans man who wants to access a women's shelter, for example. There may be some problems in being able to access that, but it would depend on the individual, a little bit on the individual circumstances.
Okay, well, that person with that question, you're welcome to email us. You can email webinars, webinars, at legalaid.qld.gov.au, and we can pass that question on to Matilda and Heather, and they'll be able to come up with a response for you there.
And I should also add, some say women's shelters may have an exemption allowing them to discriminate on the basis of gender. That unless the exemption specifically allows them to discriminate on the basis of gender identity, that advice still applies. That a woman who is a trans woman should still be allowed into a women's shelter where they have an exemption on the basis solely of sex, not gender identity.
Thank you for that. We've also just had someone who might have had a client in a situation with discrimination where a business has been involved, and the business isn't actually aware of the orientation that's being discussed with them. Would that person be able to elaborate a bit further on their question, I believe? And see what's come through.
Oh, do you mean can you, perhaps it means can you ask an employee about their sexuality if you don't know? Usually that might be discrimination to require someone to out themselves in the workplace where they don't choose to do so. There may be a genuine reason why you suspect that person is being bullied on the basis of their sexuality or something like that. So particularly because, that's particularly, in some scenarios like in schools they might have to ask, but generally that information is actually considered private. Your sexuality is your private information, so it might be a breach of the Anti-Discrimination Act to ask, but it also might be a breach of information privacy principles. So be very careful with that question. Consider, why are you asking that question? Is it just my curiosity? And in that case, you shouldn't ask.
And something I'll just quickly add to that, Matilda, is, and I did allude to it before when I was talking about the different types of complaints we've received, but there's actually another section of the Act that we haven't talked about too much today, which is basically unnecessary questions is what we call it. And that's if there's a question on which discrimination may be based is asked. And so if someone was to ask that question, and for not any genuine purpose, as Matilda's raised, and it's possibly for the reason of discriminating against that person, then that actually might be a separate breach of the Anti-Discrimination Act, along with discrimination.
Thank you. I believe we've only got time for one more question today. So, however, you're all welcome to use the webinars at legalaid.qld.gov.au email address, and I'll be able to pass that on to Heather and Matilda, and we'll be able to get some responses back for you. But the last question we'll take today is, what happens if someone's in trouble with the police and they identify as a particular gender, but the police officer is purposefully misrepresenting their gender and calling them a male even though they may identify with a female? How can they get around those issues?
Well, that's discrimination, because the police are required to follow the Anti-Discrimination Act. And so for anyone who's in any public office to deliberately misgender somebody or deliberately use the incorrect name, there are maybe some circumstances where police are required, like writing up the warrant may need to be in the correct name. but generally when they're referring to someone, should refer to them as he or she as they, the pronoun that they identify with. So, yeah, police are equally covered by the anti-discrimination laws.
Okay, good. I hope that's been helpful for everyone. Would you both be able to just tell us what's the top point that our audience could take away from today's webinar, please?
Just if you have a question, even if you suspect that you might be being treated less favourably because of your gender identity or sexuality, please just ring up, get the information. It doesn't mean you need to take it any further, but find out what your rights are under the law and what might be the avenues to exercise those rights.
And I'd say something, probably a takeaway message fairly similar. Again, we've got the option of calling up anonymously and putting your scenario to us, and our intake officers are very happy to talk you through where it might fall under the Anti-Discrimination Act. And just don't be deterred by, it might seem like a really complex process, or maybe a process that you don't feel particularly comfortable in complaining, but our conciliators are very supportive of all parties to the complaint. We're really there focused on giving everyone a fair go, and evening up the power imbalances if there are any, and so we'll do our best to actually help you go through the complaints process in a way that's, like, I guess, least disruptive to your life, and hopefully to get you a good outcome. So yeah.
Thank you. I just want to say thank you to Matilda and thank you to Heather for joining us today and giving us this great presentation and being here to answer all of our questions. There were a few more that we couldn't get time for today, so just a reminder again to email us, and we'd love if you could also keep an eye out on the Legal Aid Queensland website under the Information for Community Workers and Carers page, because we run regular webinars. We do 10 a year, normally on a Friday, so please check back and see July and August webinars. They'll be loaded soon. And as Heather and Matilda said, just give us a call, Legal Aid Queensland and ADCQ a call, or send us an email, and we'll be able to help you, or if we can't, we'll be able to direct you to the best place for you and your clients to get help. So thank you everyone, and have a great weekend.
Thank you.
Thank you.